Good evening, InteleTravel Agents. This is Tara Minson, Vice President of Marketing and Communications, and I want to welcome all of our InteleTravel agents to our interactive webinar, another one of your exclusive, inspirational, educational, and always fun events for you. Thank you, everybody, for taking the time out of your busy personal evenings here to help join us and help grow your travel opportunity over there in the UK. I'm excited to be conducting this webinar as it is a really important topic, of course, and we've got a very awesome presenter that is going to be conducting this training with us. So just as a reminder, this is a two-part training series. This is part one of our two-part training series for this topic. So I just want to remind everybody of that before we start. We'll remind you at the end as well. But please make sure you watch your emails and see your excellent online calendar of events in your back office site at InteleTravel.uk for more special guest appearances by all of our travel partners. And of course, as we roll out a whole new webinar series, again, with partner trainings and announcements all along the way. As our regular training and webinar events are always Tuesday evening and Thursday evenings at 9 p.m. 9 p.m. British Standard Time. But if you happen to miss this, or you know of somebody who happened to have missed this webinar, they can always download it and replay it in our archived section of your agent back office site called InteleTutorial section. So all of this training, of course, is brought to you free by InteleTravel.com. So again, thank you guys for joining InteleTravel's first mandatory UK regulatory compliance webinar. General Data Protection Regulation, GDPR, for the EU can seem overwhelming for most agents, but we are working to simplify it in this two-part series training, giving you all the background and history for full understanding of GDPR. And next, we'll be helping you create some tips and provide a better understanding of GDPR and the practicality and uses of it in your home-based travel business. This part one webinar series will cover the overview of GDPR and the effects on the travel industry and particularly travel agents. Security for your clients and peace of mind for you as you run and operate your business as an InteleTravel agent is always our top priority. So now, more than ever, it will become necessary and mandatory to ensure cybersecurity protection and prevention measures are in place in order to avoid data breaches and hefty sanctions under GDPR. You are not alone. And InteleTravel's compliance trainer and partner and experts are here to help you all along the way. And we are not alone in this education of GDPR, as we have teamed up with Joanna Kolatzis as our legal advisory, and she comes with a 20-plus year of travel experience, industry experience. She spent years working with APTA and is not only a member herself, but is also vested with APTA's policies and procedures, and we feel she is the best partner that we can have with us on this next chapter of education and training for our agents. So without further ado, I would like to bring on Joanna and have her take us through this webinar. As always, you can use that question box found on the control hand panel at the right-hand side of your screen. So as Joanna goes through her presentation, you can type in any questions from in that question box there, and we will read and answer as many as possible during the end of this webinar. So, Joanna, I'm going to let you take it over, and I want to thank you personally for giving up your personal time from your evening, putting together this training, helping us actually understand it better, of course, in this two-part training series. And again, for joining us here and being fully vested in our agents and our agents' education and compliance throughout the way. So I want to just thank you for that first and foremost. So how are you doing, Joanna?
I'm good, thanks, Tara. Great to be here, and thanks so much for that great introduction. I've got big shoes.
Well, I mean it. You do the hard work for us. So you are a completely important part of running our travel business in the UK, of course. So you of course are a wealth of knowledge, but you're going to be a tremendous asset to our agents and education across this way. So I mean it. Thank you.
Thanks a lot. Okay, so let's get started. Good evening, everyone. Thank you for joining us this evening, and I do hope you find this webinar on the EU General Data Protection Regulation both informative and useful. Do bear with me while I take you through some complex regulations that we've tried to really simplify just so that we can get to the heart of the matter so that it's interesting and informative for you. So what is GDPR? It's a new set of EU data protection laws that came into effect on the 25th of May this year and governs how you collect, use and hold customer data. You've probably all heard lots of information about GDPR, particularly in the run-up to May this year. And I'm sure you all had a raft of emails asking you, as did I, to resubscribe and sign up to certain newsletters from some of your favourite online shopping sites. This was all because of GDPR. If this is all new to you, please don't panic because we are here to help, as Tara said. The good news is that the regulators were aware of the potential impact of GDPR on businesses as a whole and are really taking a light touch approach at the moment while everyone gets used to the new normal as far as data protection is concerned. So the objective of today's webinar is to provide you with an overview of how the GDPR and the Data Protection Act 2018 in the UK affects the travel industry and particularly travel agents, and provide you with some key takeaways. It will help you understand the obligations that have been placed on businesses as a result of GDPR and identify any potential warning flags. But as Tara said, you aren't alone. This is an EU-wide piece of legislation, and it doesn't just apply to travel, so it really does affect everybody that handles and controls data within the EU or for EU citizens. So we've decided to issue the training in two parts, as Tara said, so it's easier to get to grips with. This first part will focus on the regulations themselves and the main issues to be aware of. We also have a part two planned to go through the practicalities of some of these issues that we'll be looking at today and where we can apply this to some of the scenarios that you're likely to face. From our perspective, the way we're looking at it is that if we help you understand the background to the regulations, it will be so much easier to apply it to your day-to-day activities as a travel agent so that you know exactly where to go to find the information you need to service the customers in the right way. So before we get stuck in, please save any questions you might have until the end of the presentation or send them via the chat box that Tara mentioned. I'll be looking at quite a few issues during the webinar, but we'll be able to answer any questions following the presentation. So please don't worry if you feel like you need a bit more information or you need to know a bit more. So let's have a quick look at why the GDPR was needed. It was introduced to develop better protection against the abuse and misuse of data. This includes unsolicited marketing without consent, data sharing between third parties, and continued use of data beyond the intended purpose it was originally provided for. In the travel industry, we handle a lot of data, and so we have to be especially vigilant to ensure that we collect, handle, store and delete data in order to protect our customers and our business. The GDPR now gives us a distinct framework to work within in order to achieve this. So on the back of the initial reasons as to why GDPR was needed, let's take a closer look at some of the background and an overview. The GDPR represents a significant gear change for data protection across the EU. It's been billed as an evolution of data protection regulation, not a revolution. The main aim is to provide a one-stop shop oversight and regulatory system in each of the EU member states and provide clarity in view of the ways in which data and the use of data has evolved over the years. It goes without saying that the digital world we now live in means we share a lot of data through online platforms, and it's harder to control where this data is held and who's responsible for it. You've probably all heard about the big data breaches suffered by the likes of Yahoo, TalkTalk and Facebook recently. It is these breaches that the new regulations aim to provide some protection against and a method for dealing with them in the unlikely event that you suffer a breach. So let's start by looking at the GDPR and its origins in a very quick way. So in April 2016, the European Parliament, Council and Commission finally agreed the wording for the EU GDPR, which was published on the 5th of May 2016. As an EU regulation, it became directly applicable across all EU member states as of the 25th of May 2018. Following a 2-year implementation period, businesses are now operating within the confines of the new Data Protection Act 2018. The objective of the GDPR is to harmonise data protection regulation across the EU. Over the course of time, data protection law varied from state to state, and the aim of GDPR is to bring some much needed clarity as to how EU data subjects can expect their data to be handled across the EU and beyond. The GDPR now takes account of the digital world that we live in a way that its predecessor, the Data Protection Directive, never did. For example, when the original DPD was published, we didn't have social media platforms or online shopping in the same way that it exists now. GDPR attempts to bring data protection regulation right up to date with digital and online behaviours in order to provide maximum protection to EU data subjects. In our case, those EU data subjects are our customers, and of course we take the protection of their data extremely seriously. So the key rights under the GDPR are shown on this slide. Some are expansions of current data protection rights and some are entirely new. Please don't worry, I won't be taking you through each of these key rights individually, but we'll be discussing some of the more pertinent changes in the next slide that will affect the way in which you collect and use customer data in your daily activities as a travel agent. Some of these rights will have more of an impact than others and will determine the way in which you manage data going forward. It's important to understand the obligations under the GDPR in order to obtain data from customers in the right way and be able to answer any customer queries about the handling of their data. This is all contained in the InteleTravel data protection information that customers will have access to, so it's good to be able to direct any queries they have to the right place. Some of this may seem a little daunting, but please bear with me and remember that there is a lot of support within InteleTravel for the benefit of you and the customers. So some of the key changes I referred to earlier and which will have a direct effect on the services that you'll be offering through InteleTravel are the following. Bear with me while I take you through this. This is probably the longest slide that I have just while I explain the background to each of these specific criteria. So extraterritorial application, what we mean by this is that the GDPR applies both inside the EU and also to third countries where they are controlling or processing the data of EU citizens. In a nutshell, even if you're not an EU-based organisation, if you process or control data related to the offering of goods or services to individuals in the EU, regardless of whether or not a payment is required, or you monitor their behaviour, insofar as that behaviour takes place within the EU, you will be expected to comply with the GDPR. There is a big push towards accountability in the GDPR and the need to hold organisations responsible for data control and processing in general. Previously, all that was needed was an annual registration to the National Data Protection Authority. Now, organisations have increased responsibilities to maintain detailed records showing data protection compliance. The need for this will become evident when I tell you a little bit more about the penalties for breaches. Personal data and sensitive data are key items within the GDPR. Personal data is defined within the GDPR as any information relating to an identified or identifiable natural person. That makes them a data subject. This gives us the foundation for identifying a data subject, and that list is very broad. The means of identification can be a name, an ID number, location data like an IP address, or one or more factors specific to the physical, genetic, physiological, economic, or social identity, among other things. You can see, therefore, that this definition of personal data alone is really expansive. Special categories of data are also called sensitive data and remain within the GDPR, but are extended to include biometric and genetic data. So, for example, passport data and passport information is considered to be biometric data. I mentioned earlier that the GDPR is much wider in scope than its predecessor, the Data Protection Directive. Having just mentioned a few of the key changes so far, you can see just how much broader in scope it is and the justification behind the EU's extension of data protection rights across the EU. Consent is one of the biggest changes to the current data protection regime, and you've probably heard tons about it, especially in the run-up to May this year. The provisions surrounding consent are now a lot stricter. Under the new regulations, consent given by data subjects must be given freely, specific, informed, and unambiguous. There is no implied consent, and consent cannot be assumed. I will be talking about this in the next slide. Direct compliance for data processes is a new key feature. Before the GDPR, it was the data controller who took the lion's share of the responsibility for compliance. But now GDPR introduces direct obligations on data processors and gives data subjects the right to enforce against them directly. Data processors will no longer be able to rely on protection from the data controller, and both can be held responsible in the event of a breach. Privacy by design and by default is another key change under the GDPR. It introduces the concept that data protection processes and procedures need to be developed to fit the business at hand, as opposed to an off-the-shelf IT solution in isolation. This is the system that InteleTravel will have in place and provides the framework that you will be working within. So privacy impact assessments will be mandatory in certain circumstances, for example, where processing of special categories of data or data processing take place on a large scale, among other criteria. The travel industry, of course, falls into the category of data processing on a large scale, and we deal with large amounts of sensitive data as well. This falls again within the InteleTravel data protection procedures, and PIAs will be conducted as necessary. If there are any particular measures that have to be implemented as a result of any PIAs, InteleTravel will be sharing this with you to incorporate into your booking processes. So data protection officers, or DPOs, is not necessarily a new obligation to some EU member states, but it is in the UK. So data controllers and data processors must appoint a DPO where the processing is carried out by a public authority, or their core activities involve monitoring individuals on a large scale, or where they process special categories of data on a large scale. And you've guessed it, that's exactly where the travel industry falls again. So the DPO must have expert knowledge of data protection law and practice, and will be the gatekeeper for the data protection policies and procedures implemented by the business and ensure compliance. Your InteleTravel DPO is Tara Minson, who's on the webinar with us today, and she is our resident data protection expert. So I mentioned these increased penalties for breaches earlier, and this change is perhaps the most talked about part of the GDPR. It's also why compliance is going to be especially important, because we now have a much heavier penalty system in place by way of a two-tier system of fines. Now, I should highlight that those fines, if they ever become applicable, are levied towards the company, and of course InteleTravel will be on hand in the unlikely event of any breach. But what we wanted you to understand today was why it's really important to get a feel for compliance and why we have to keep up with compliance and ongoing training, so that we can avoid ever getting to the confines of a fine. So what are those fines? So the first is up to 2% of annual worldwide turnover or up to 10 million euros, whichever is greater, for violations relating to internal record keeping, data processor contracts, data protection officers, and data protection by design and by default. And the second tier is up to 4% of annual worldwide turnover, or 20 million euros, whichever is greater, for violations relating to breaches of the data protection principles, conditions for consent, data subjects' rights, and international data transfers. Now, I should caveat all of this by saying I really don't believe that these top tier fines and the top level of those fines will be levied towards companies that are of similar size to us, but probably will be reserved for the Facebooks and the Apples and the multi-billion-dollar corporations of this world. But nevertheless, hefty fines are capable of being applied, and so we want to avoid those if we can. So mandatory notification requirements are a new concept, and in the event of a data breach, this must be notified to the relevant supervising authority. In the case of the UK, this is the Information Commissioner's Office, and must be notified without undue delay and within 72 hours of the breach occurring, unless it is unlikely to result in a risk to data subjects concerned. In the event of a breach, you would be working with your DPO to ensure all the necessary procedures have been followed, and if you have any doubt whatsoever, you should be notifying your DPO anyway, who will make a call as to whether or not it's a breach or not. So please note that in the UK, we do now have a large amount of guidance which is in place and issued by the Information Commissioner's Office, and they will be our regulatory authority for the purposes of the GDPR. So some of this guidance is really useful, really simple and easy to understand, and it can assist in further understanding the key changes and implementation of the GDPR. It's worth taking a look if you haven't already seen this, and we would be more than happy to let you have some links for ease of reference if you wanted to have a little look through that yourselves. So I mentioned earlier that I would spend some time focusing on data subjects specifically, because the GDPR is all about them, and the new enhanced rights afforded to them under the GDPR. In essence, individuals will have much easier access to their personal data and information about the data you hold in relation to them. There will be greater transparency on the reasons for processing. So, for example, what data do you hold? What do you need it for? What are you going to be doing with it? How will you store it? And how long will you be keeping it for? These are all the questions you have to be able to answer when you ask someone for their data or for consent in relation to a specific purpose. So they will have the ability to access their data, but you won't be able to charge for providing them with a copy of their file. In terms of data portability, data subjects will now have the right to request a transfer of their data to another service provider. So for example, you could get a request to have their file transferred to another agency. All that we would suggest you do in that scenario is obviously advise the DPO and follow the correct process. But you also have to make sure that you've carried out an identity check so that you are absolutely sure they are who they say they are. Otherwise, you could be in breach of transferring data to somebody else who never had a right to it in the first place. So these are all the issues that we need to be aware of. There is also the infamous right to be forgotten, or the right of erasure. And this was made very famous by a case against Google a couple of years ago that you might have heard about. And it was in relation to information that was stored on the internet through what they call cached pages, so in searches. And Google were challenged and forced to delete the records of the claimant, who argued that actually this information was historical, and I think all of his previous misdemeanors had been discarded, and so he shouldn't be, a billboard on the internet for all of these horrible things that he may have done in the past. He won that case, and now everybody under the GDPR has essentially the same right to be forgotten, and a data subject or a customer may ask you to erase all the data that you have on file for them, and if that happens, we have to comply. Finally, there are rights in relation to automated decision-making and profiling, and the right to object to profiling. This is actually only permitted in certain circumstances and where it doesn't unduly affect a data subject's fundamental rights, or where they've given explicit consent for their data to be treated in this way. I talked about consents earlier, and just to reiterate, specific consent is going to be a key feature of GDPR. There is no longer the option of a soft opt-in or bundling of consents. You have to be clear about the data you're requesting and ensure you have consent for the specific purpose you intend to use it for. In some cases, you might be looking at a menu of consents if you provide a variety of services. So, for example, to facilitate a booking or to make an inquiry or to transfer data to other providers once a booking has been made. So it may be that consents are put into a sort of a menu, if you like, and the customer chooses what they are and are not agreeing to. So this is all contained in the data protection policies that InteleTravel has in place, and will also be fully explained in the privacy policy that your customers will have full access to, and that we'd encourage you to read through yourselves, because it does tend to make sense once you've seen it all in black and white. So this next slide is a helpful visual snapshot of the obligations you will have as a business, both internally and externally, when seeking to comply with the GDPR. Now, taking the consumer issues out just for the moment, on the left-hand side, we have this internal column, and these are the internal obligations that a business may have, for example, for employment purposes. This is really just for information and to demonstrate just how far-reaching the GDPR is, so that you can better understand that it doesn't just affect the sales environment, and it really affects any individual who is an EU citizen. Moving on to the right-hand side and the external considerations, this is the critical part for us and for you today. This demonstrates the data collected and gathered from a consumer point of view and the relevant data flows. The data comes to you for the required purpose, and you then filter it out to relevant suppliers, perhaps for dietary requirements or passport information or medical or assistance information that is specific to the customer, and without it, you can't properly provide a service to them. Once the data is transferred to other parties, the obligations continue to grow, as you see. This is where the relationship between the data controller and the data processor crosses over, and contractual protection is really important. In some cases, you can actually have joint controllers as you're both gathering data for different reasons. This is where InteleTravel will have relevant agreements in place with suppliers to ensure the obligations on both sides are clearly defined. At the very end of that external considerations column, we're reminded of the responsibilities as either controller or processor, but also the implications for the customer if data is transferred outside of the EEA, which is the European Economic Area. And it does frequently happen in travel because suppliers can be all over the world when you're fulfilling a holiday booking. If you can visualize just how many different streams of information are collected in order to make a booking, you can probably imagine how hard it is to control all of that data and safeguard it, which is one of the reasons we'll be helping you with that on an ongoing basis. I'll be looking at the way in which data flows during an inquiry and booking process in the next slide, which will help frame all of this a little bit further. So now that we've considered the obligations under the GDPR, let's try and apply it to your activities as a travel agent. In doing so, we've really thought about the various points at which the travel industry gathers and collects data. There are various touch points to consider in terms of data gathering for the service provision, but please always bear in mind the issue of consent and your data protection systems in place. So we've highlighted a list of issues that are relevant here. For example, from the moment the booking request is made or an inquiry is received, the information that you're given in order to respond to the query is relevant, and that is data. At the point of reservation and payment, more detailed and financial information is given to you in order to complete that booking. When you transfer information to suppliers for the provision of various services, information is loaded into the system to ensure the booking is performed, and the suppliers are notified of their ongoing obligations in making sure that that contract is fulfilled. During the stay in resort or during travel, they will provide you with information in the event of further additional requirements, so particularly special assistance, medical, dietary information, health information, or information about children and their needs. And remember that children and some of the information that I've just mentioned is actually within the sensitive data category and needs to be treated with particular care. And this will be enhanced in our Part 2 training. In the event of an emergency during their stay and in respect of any sensitive data issues, including children again, there are further data touch points there to consider. Do you have the appropriate consents in place in order to fulfill every stage of that booking process? What if there is an emergency in resort? Do you have next of kin details? Do you have the ability to contact their insurance company if they need some assistance so that they can pick up the baton? It's this sort of information and the sensitivities involved that we need to make sure we've covered in terms of that booking process and the collection of data. So it's easy to see that due to the nature of services provided by the travel industry, there are a number of data touch points to consider and protect. For this purpose, it's really important to obtain the correct consents, as I mentioned, so that we're handling and processing that data that has been supplied for the correct purpose. In addition, you have to be clear about how long you will keep the data for. Remember, it's only necessary to keep data for as long as it is required to fulfill the purpose for which it was collected. There are, of course, exceptions to this, perhaps in relation to tax and legal issues, although you may have to sensitize some of the data or anonymize it in order to comply with your ongoing obligations under the GDPR. So, for example, there's never any reason to retain payment information once they've paid for their booking. All you would need to do is confirm that they've paid for their booking. You don't need to contain or retain their credit card information, for example, on an ongoing basis. And this is where InteleTravel's policy will come in and offer you further guidance on it. The added benefit of regularly purging data, of course, is that the less data you hold, the less chance of a significant breach taking place. InteleTravel's privacy policy will outline the data subject's rights, and it's recommended that you familiarise yourself with this in case of any customer queries. I mentioned the ICO guidance, and again, there is some useful information on the issues of consent and retention of data throughout that ICO guidance. So it's worth taking a look if you wanted some sort of a bit more meat on the bones as far as what's available there. So in the unlikely event of a data breach, the business will have to demonstrate that measures were taken to prevent the breach and mitigate the impact of any breach. This is again where InteleTravel's overarching data protection policy and relevant procedures will take effect. This slide gives us a really brief overview of the steps necessary for GDPR compliance and why it is so important to familiarise yourselves with the support that InteleTravel have put in place. It will also help you to understand where you need to go for relevant information in the event of a data protection query you may receive from a customer. So firstly, there's the issue of a gap analysis, audits and privacy impact assessments, which will, in terms of raising awareness of the obligations under the GDPR within the business, is really important. It's one of the reasons we're providing you with this webinar today. InteleTravel will be conducting any necessary privacy impact assessments, audits or gap analysis in order to update compliance measures as and when necessary. GDPR focuses on accountability, and this is intended to be a top-down management approach, something that InteleTravel takes really seriously. On the back of any assessments made by InteleTravel, there may be further actions and decisions to take in order to implement these changes within the business. This is something the DPO will be advising you of. Policies, procedures and documents will be developed and implemented in line with your activities as travel agents. Once you've familiarised yourselves with the documents in place, you will have a better understanding of how to deal with any data issues you face as you progress an inquiry or a booking. We will focus more on this in part 2 of our training, where we get into more of a scenario-driven training experience. Review your security measures, and I talk about security from both an IT perspective but also a physical security perspective. A lot of data issues are focused on IT breaches, but it's important to remember that data breaches can occur due to documents lying around, not just due to data hacking and IT issues. Physical data is also data and should be protected in the same way. Be wary of what you leave lying around on your desk and think about security measures that you have in place. Think about any further systems that should be implemented and make your DPO aware of any issues you believe ought to be considered for your ongoing protection and the protection of the data. There are also cyber essentials qualifications that can help you evaluate the risk areas in terms of security. So implementation, training and ongoing governance and compliance will be crucial on this journey. Once you're fully apprised of the systems in place, you must ensure you adhere to them. GDPR will be a live and ongoing issue. It will require constant monitoring and will evolve over time because it's a new regulation and we have yet to have any case law or any big decisions or fines that determine the way in which the regulators will be dealing with breaches going forward. So we still have a long way to go and it will be a learning process. Your DPO and management are aware of all of these issues and will monitor the business to keep on top of ongoing compliance and arrange any top-up training as and when necessary. So we've considered the background and main functions of the GDPR. So what next? The following can be used as an almost unofficial checklist for your purposes. So liaise with InteleTravel to understand any documents in place and any risk assessments you ought to be aware of. The InteleTravel team will ensure you have all the information you need about the systems in place. Review the data protection and privacy notices that are issued. Consider your activities in line with the policies to ensure compliance with the privacy by design and by default concept. It's really important to make sure you understand the policies so you can properly direct any customer queries in case they have any data protection queries. From a customer perspective, consider what consents you require to fulfill the contractual obligation. Do you have consents in place already that were pre-GDPR? And consider whether these are still relevant or whether you need to obtain fresh consent to ensure compliance with all of the purposes that you'll be processing data for. For example, any customers that you might have dealt with pre-GDPR and were already customers on your database or had booked a holiday with you may already have the correct consents in place, but it's worth taking another look. The processes in place will document how you hold data, for what purpose and how long for. You also need to consider policies for compliance. So if you have a request to rectify data on file, for example, how do you deal with it? Or if somebody wants to withdraw their data. For example, if you receive a right to be forgotten request, you need to pass it on internally so that it's properly tracked and actioned. There has to be an audit trail in case of any perceived breach in the future. Similarly, the right to withdraw consent and how this is actioned could be a major issue going forward if it's mishandled. So it's important, as tedious as it may be from an administrative perspective, to make sure that we continuously tick all those boxes and get it right. Finally, data protection, breaches and notification process will be crucial if we're to avoid any further investigation or sanction. So if you have any concerns about a possible breach, please do alert Tara immediately as your DPO. InteleTravel will be handling any necessary contractual documents with suppliers in order to ensure protection measures are in place in the unlikely event of a breach. The team may need your assistance in dealing with any complaints arising from an alleged breach, and familiarity with the policies will really make it easier for us to respond to if we're ever faced with that eventuality. So on that note, I've completed my part of the presentation. I'll be handing you back to Tara, who's got a couple more slides to take you through before we move to the Q&A. Thank you.
Yep, absolutely. Thank you so much, Joanna. That was awesome, and I think everyone, if we can just take a deep breath real quick, and of course understand that this is part one of a two-part training. This was a great overview, and of course, Joanna, I'm just gonna make myself the presenter so I can start the presentation from my portion. But again, I just want, or actually, Joanna, would you like to?
Want me to just move them along? I'm happy to do that.
Yeah, there you go. Why don't we?
There we go.
Yep, I just have to make you the presenter again. I apologize. I just took over the screen a little bit. But the purpose of this, by all means, was certainly to give you an overview history, regulations, and really a deeper understanding why. It was not meant to be scary. It was not meant to be overwhelming. This was really just a background for what is to come in the two-part training, of course, part two training, and also what is to come in the next email communications with helping us get regulated and compliant. So you have all received the email about a month ago, I want to say. Perhaps a little less about the InteleTravel GDPR breakdown. We summarized it for you. We actually gave you a great letter for you to actually use for your clients so that they just have an understanding that you are aware of this, because our clients sometimes are really savvy and more savvy than we think they are and give them credit for on regulations and rules and policies and everything. So you want to make sure you let your clients know that their protection is your utmost important topic, of course, and we have the responsibility, of course, to ensure that all of our customer data is treated with the same respect and confidentiality. So we gave you that email for you to email your customers out to reassure them that their use of their data is fully protected. There is that template that you are welcome to edit, of course, and use, and it's just a great background for you. There will be more. There will be an actual form that we will provide for you. Like Joe said, we're updating our privacy statement, and we will be providing that for you as well. So this is purely just to let your customers know, if you have not already used this, that you are becoming fully compliant, and that their confidentiality and their data is, like I said, incredibly important. If you're already working with clients, of course, this is a great email to send them as well. So please use that email. We will actually resurface that email again so that anybody who has missed it can have it again. We'll also put it in the Facebook, InteleTravel UK Facebook page as well. But it's really important to have that and to make sure your clients are fully understand about it. So Joe, before we move on, do you have anything else that you would like to add before we move to the next slide?
No, I think you covered everything there, and I think that the statement and reissuing it potentially is a really good way of just double checking that everything's in place.
Right. Okay. So you can move to the next slide there. And just in continuing on consumer rights, of course, this is just a basic overview. Again, this is so that you can understand, and this is, again, everything Joe kind of went over, but you can also use this. This is also in that email for you, so that your clients also understand their rights and better understand it. This is not intended to scare your clients, of course. This is just so that they understand what their rights are, because there may be a lot of information out there, but there may be a lot of misinformation. And they may be getting misinformation saying, somebody telling them that, what their consumer rights are and what you as a business are and are not able to do, and they may be getting the wrong information. So you want to make sure you provide them with the correct opt-in and opt-out and the privacy statement, which is coming, of course, from us, the updated privacy statement, and what their rights are there. Like Joe had said, verbal permission is not allowed. It is not considered compliant or acceptable. Permission has to be in a form of writing. Part 2 of this mandatory compliance training is going to have the practicality uses of it for your business. By that time, we will also have all of this in place, but you need to have an understanding of it prior to us, of course, pushing out this form and the new privacy statement. We want to make sure you have a full understanding of where it is coming from and the importance of it and the severity of it too. So part 2 will be this global consent form that you will be able to give to your customers, and it will be your written form, of course, providing that they are giving you permission to contact them, email them, market them, and of course hold all of their data protected. So that is certainly coming before the next training. And on that note, on the next slide, is our next Part 2 training date. So you can certainly mark your calendars for September 13th, 9 p.m. British time, of course, and that is a Thursday evening. And this will be the part 2 of the part 1 series here, of the 2-part series here. And this is where we're going to take, like I said, a deeper dive and give you some practical uses for your business. We're going to show you that opt-in form. We're actually probably going to push it out prior to, but we'll show it to you on that webinar, how to use it. And again, the right time to request permission, which we all know that now from this webinar, is in the very beginning and prior to. And of course, how to store protected customer data responsibly. Practical safe GDPR uses, of course, in your business. And also, I'm going to take you through a step-by-step guide and process from introduction, communicating with your clients from step 1 all the way to the booking process. So that is what we are intending for the part 2 training, of course, and that is coming on September 13th at 9 p.m. So this portion, albeit I understand it may seem overwhelming and maybe a bit confusing, and it was, this was intended to actually give you the background of it. So I think, Joe, you did a fantastic job of breaking it down for all of us and giving us a bite-sized history and regulatory reasons behind everything, so we understand the severity of it. We can communicate to our customers now the proper way with the additional email that we pushed out earlier. And the practicality uses, like I said, are all coming. Just as again, as a little introduction, I said it in the beginning, but Joe was selected as our legal advisor because of her, of course, years of experience in this travel business. She understands what it is like to run and what you need to operate your travel business. So she's got years of travel industry experience. And of course, she spent years working with APTA directly. And she is fully vested and on board with us throughout this next phase of our journey until we've got that APTA membership approval in conforming and providing all of the required mandatory education required by APTA, by ATOL, and any other UK, EU regulatory changes and policies that come in place. So that is, the reason why, of course, this is super important. So, Joe, before I take some questions, is there anything else you want to kind of add, or?
No, I think you've covered everything, so thank you for that, and I hope it wasn't too scary, but it gave the background that we intended to for everybody. But I'm happy to take some questions now, if there are any.
Perfect. Perfect. This is actually a great question. Will these regulations change when